Hey everyone, welcome to another edition of The Bullet. My name is Paul Lathrop. I'm the Deputy Director of New Media for the Second Amendment Foundation. Joining me today, as he does every other Friday, Alex Ooley of the Ooley offices in Indiana. Ooley, thanks for coming on again today, man.
Yeah, great to be with you, Paul.
Let's. I want to start out today. Before we get going, as I always do, I want to remind everybody if you're watching on the Polite Society podcast feed, you either on Facebook or YouTube, you can get your comments in by commenting on the live video. We'll get those comments up. We'll talk about them on the air. If you're watching anywhere else, if you're watching on the OpsLens app or anywhere else that picks us up, go to Twitter, tweet with the hashtag #TheBullet. We'll get those comments in as well, and we'll get your comments on the air. We'll discuss them. Alex, I want to start off with today, and it does dovetail into one of our stories later. I want to talk about something in legal terms called standing. In one of the stories, I believe it's the New York story, one of the lawsuits that Gun Owners of America brought was dismissed earlier this year because the person they had teamed with to bring the lawsuit didn't have standing, and so which seemed odd to me because this particular person did live in New York. But let's talk a little bit off the bat, if we could. What is standing, and why can't you or I sue the state of New York or New Jersey or California or Hawaii and make them come to terms and do the right thing?
Yeah, so this concept or doctrine of standing is not something that you'll find in the Constitution, but it stems from Article 3, Section 2 of the Constitution, which says that the judicial power extends to cases or controversies. And basically, the courts over the years have taken this cases or controversies provision of the Constitution and developed this doctrine of standing, which is simply the ability of a party to bring a lawsuit in court based on them having some sort of stake in the outcome. So if you're not affected by the case, you wouldn't have standing to sue based on a certain law or harm. So there has to be some injury to the person who's bringing the lawsuit. And if you're challenging a law, the law has to have caused that injury or harm. And then it has to be something that is what's called redressable by the courts, which just means that it's something that the court can fix. It's a problem, it's a harm that the court can fix. So in New York, with the Concealed Carry Improvement Act, as it's so called, me living in Indiana, I'm not affected by that. I have no plans to go to New York. I'm not going to be affected by the new law that was implemented or passed in July. So I wouldn't suffer any sort of harm from that law, and therefore wouldn't have standing to sue to overturn that law. So that's what's happened in New York. The Gun Owners of America have filed suit, and I believe the reason it was overturned initially, and we can get into this later, was that the plaintiff had no, I think, indicated that he had no plans to violate the law. And if he's not going to violate it, that means he's not suffering any harm from the law. So the court found that the law was unconstitutional, but he lacked standing, so the case was initially dismissed before it was refiled at a later date, with some additional plaintiffs who did intend to violate the law.
Yeah. I find that interesting. In order to sue, I have to tell them I'm going to break this law. That seems counterintuitive and rather dangerous to me. But if that's the way the legal system works, that's the way it works.
Mm-hmm. Yeah, and the reason for this cases or controversies requirement in the Constitution was that so we wouldn't have courts that were simply sitting back and pontificating about potential or hypothetical problems. They wanted the courts to address real problems, and that would sort of help keep the courts out of the province of the legislature, because that's what the legislature does. They look at problems that currently exist. They look at problems that they think might arise in the future and try to prospectively address those issues. that's not really what the court's doing. The court is
It's not really what the legislature's doing either, but that's
theoretically, right? That's what they
they're
should be doing.
supposed to, but yeah, they're really not.
Exactly. So standing, it can get pretty nuanced and complicated, but that's the basic concept: is that you have to have suffered some harm. The law that's being challenged has to have caused that harm, and the court, it has to be something that the court can correct.
Okay. And I forgot to do it at the top of the show. We should have absolutely done it at the top of the show. We do it every other time you and I are on together. I want to mention that you are an attorney. You're an attorney in Indiana, but nothing we are saying should be construed as legal advice. If you need legal advice, get advice with an attorney that is licensed to practice in your area. This show is intended for educational and entertainment purposes only, not legal advice.
Exactly. And one thing I'll mention, Paul, that comes up a lot with the question about standing is that there's this exception. There can't be a plaintiff who is suing for an injury if it's something that's so wildly shared or undifferentiated from so many people. And you might guess that the most common exception to this is taxation. So, of course, the government has carved out an exception for taxation because everybody, of course, is harmed by taxation. But you can't sue the government based on a tax law that's widely applicable to lots of people similarly situated. So, for example, and I don't want to get in the weeds too much, that's one of the problems with the recent announcement on student loan supposed forgiveness, is that the people who are affected are who are harmed by the proposed forgiveness are taxpayers. And so how can they sue to overturn this student loan forgiveness when the only harm they're suffering is this, that it's going to increase their taxes theoretically at some point in the future, or at least be incurred through debt that causes inflation to go up, et cetera.
Right.
So that's an example of a harm that's so widely spread and undifferentiated that you wouldn't have standing to sue for it. So that's been a complicating factor with that particular issue.
Right. And so I that one I almost get if the entire nation is shouldering the burden, so to speak, why does one person get to sue when in essence every 2 years and certainly every four we go to the ballot box and have a chance to change the direction things are going if we don't like what's happening.
Yeah.
I do have a few, and we when we have you on, we try to keep at least on Friday when we have you on Legal Friday. I try to keep the stories mostly legal related. The first story I have is that the Supreme Court vacates. This is from FISM TV News. SCOTUS vacates Massachusetts handgun restriction case. This one, in this particular case, there was a lifetime ban for anyone with even a nonviolent misdemeanor, which resulted in 2 years of jail time, even if that misdemeanor was not in Massachusetts. And it didn't need to be, I mean, most people think if you're convicted, and it's correct, if you're convicted of a violent felony, you lose your gun rights. Most felonies, you lose your gun rights. But in this Massachusetts law, even if you had a non-violent misdemeanor, you lose your gun rights. And this was overturned this week by the Supreme Court. And then Justice Thomas, in the opinion, he wrote, the Second and 14th Amendments protect an individual's right to carry a handgun for self-defense outside the home. Because of the New York issues, public carry licenses would only. Wait a minute. That's not for this. That was from the. I'm sorry, I got too deep in the article. Skipped too deep in the article. That was from the Bruin decision. What this I this seems to me just to be an extension of Bruin, though a lot of cases are finding their way to Supreme Court, and Supreme Court is vacating them, sending them back, saying, go read Bruin.
Yeah, I mean, and this is just another example of the action that's been taking place since Bruin was decided in June, just not even 4 months ago. So we can already see that the Bruin decision is having widespread impact on lots of states, especially these states like Massachusetts and New York that have these draconian anti-freedom gun laws. And I'm glad to see that laws like this are getting overturned because, I mean, let's face it, these were non-violent misdemeanor crimes. Why should someone who has committed a non-violent misdemeanor crime be deprived of the right to keep and bear arms and to protect themselves? I think that's just absurd.
Yeah. And you and I have spoken about the gun rights of convicted people before. My opinion, and I'm not extending this to SAF, but I believe this is SAF's opinion. I'm not saying it is, but I definitely say it's mine. If you've committed a crime, you've been convicted, you've gone to jail, you've served your sentence, you've paid your debt to society, when you get out, you don't have limited free speech. You get back, in most cases, your right to vote. All your other rights are restored. You ought to be able to get your Second Amendment rights back, and if you're too dangerous to have a gun, why the heck are they letting you out of prison?
Yeah, exactly. I don't know. It's too early to read the tea leaves on this issue, I think. Obviously, with the addition of Amy Coney Barrett to the Supreme Court, she wrote a dissent in a case called Cantor versus Barr, where she called into question the prohibition on people who had been convicted of nonviolent felonies. And I hope that issue ultimately reaches the Supreme Court and there's a favorable decision, because I think, like you, Paul, if people have they've accepted their punishment, they've served the time, they've done what they're supposed to do, they've gone on probation or parole and done the requirements of their wrongful act, why should they lose their rights going forward and forever?
Yeah, precisely. They're still a human. They still have basic human rights, which is what we're talking about. Pat over on Facebook side seems to agree with us. If you've done your time and you're not a danger to society, you should get all of your rights back. Yeah, we're right with you there, man. Next story, and this one off of Ammo Land, and this is the one I alluded to when we were talking about standing. This is the GOA story. A judge in New York's Northern District issued a temporary restraining order knocking down most of the state's Concealed Carry Improvement Act. Gun Owners of America teamed up with Ukrainian immigrant Ivan, and I'm not even going to attempt that last name, over the summer to prevent the CCIA from going into effect. Judge Glenn Sotheby ruled that CCIA was unconstitutional, but because, and this comes up again, I'm going to try it, Mr. Antonyuk did not intend to break the law, he lacked standing to sue. The latest case became known as Antonyuk versus Hochul. This time the GOA sued a slew of new people, including New York Governor Kathy Hochul, and the GOA. They then found other plaintiffs that did intend to violate the CCIA and refiled, asked for a TRO. The courts have held that if a law is unconstitutional, the citizens are under no duty to follow it. So yeah, the New York Concealed Carry Improvement Act, that's a joke of a name, by the way, is unconstitutional. It will not, specifically my understanding is they cannot take all of the subway system and all of Central Park and make it gun-free zones. And the social media, giving up 3 years of your social media to get a concealed carry permit in New York State, those specific things have been ruled as unconstitutional.
Right. And I think the judge did a good job going through a number of the issues here, and I don't. The opinion wasn't perfect, but I think he got a lot of things right. And the first target, as the article says, was this good moral character requirement. So in Bruin, the issue before the court in New York State Rifle and Pistol Association versus Bruin was New York's proper cause requirement. And so the state of New York wouldn't issue you a license to carry a firearm until you demonstrated some special need or proper cause. And the Supreme Court clearly said that this requirement was unconstitutional. And right on the heels of the Bruin decision, New York implements this Concealed Carry Improvement Act, so-called, and develops this good moral character requirement. So the onus is still on the person applying for a license to demonstrate that they have good moral character, whatever that means, and is clearly not some objective standard that the court was saying that states should implement when they decided the Bruin case. So this good moral character requirement was just another way to give politicians and bureaucrats discretion to deny people's right to keep and bear arms. And the court, Judge Sotheby, I think his name was,
Yeah.
said that this requirement was unconstitutional and that this was just a substitute for the proper cause requirement that had just been overturned by the Supreme Court.
Yeah, and I agree. I think he got a lot of it right. And we had a discussion yesterday, and I put forth the opinion that we're going to be for a little while playing a little bit of whack-a-mole. It's going to be the courts are going to make rulings, and the state of New York, states of New Jersey, wherever, they're going to step back a quarter of a step, and then they'll have to be sued again. They'll get knocked back another quarter of a step. It's going to be very similar to the 1950s and 1960s when Democrats back then, same as Democrats now, Democrats back then did not want segregation to end. They fought. And in the southern states, they fought hard. And eventually, it went away. And I don't think it's going to take as long as the civil rights fight did. I think we're gonna prevail, but it's going to take some time. New York is not going constitutional carry tomorrow. I'm not going to rule out it getting there, but it's not going to happen tomorrow.
Yeah, agreed. And the good news too about this opinion is that even though it's not perfect, it's early in the case. The judge entered a TRO, which is a temporary restraining order that prevents the state from enforcing this Concealed Carry Improvement Act until the case can be fully litigated. But the good thing is that the judge went through the proper analysis. The judge applied the text, history, and tradition standard that the court set out in Bruin, and he went through that analysis and issued this opinion based on that. So he didn't apply this interest balancing test that many courts had been utilizing previously. He went through the history and the text analysis and came to this conclusion. And I think it was a very well-written opinion, and I think he was right for the most part.
All right, last story I want to cover today, and this again goes to standing, and this one brings up questions in my mind when we discussed standing. But Mexico, a while back, sued meaning the nation of Mexico, sued U.S. gun manufacturers, with the notable exception of Sig Sauer, for gun violence in Mexico. And the case ended up getting dismissed. Now the Mexican Foreign Minister, Marcelo Ebrard, has told the Mexican Senate that the government's next lawsuit will be filed in Arizona, meaning they're going to be filing again. I wasn't aware that foreign states could sue. I I wasn't surprised the last lawsuit was dismissed because of standing. I didn't know they had standing to be able to sue inside the United States. That I don't know how they can do that. Any insight on your end, Alex?
Yeah, so foreign governments can sue other governments in certain circumstances, or entities like private companies in other states, especially if those companies do business internationally. So a lot of times that will bring in jurisdiction, bring someone else into the jurisdiction that like these gun manufacturers operate in. But the other important point about this case is that this is spot on with the Protection of Lawful Commerce and Arms Act. Just because so many firearms are going to Mexico and being used in crimes there doesn't mean that Smith & Wesson or Colt or whoever should be on the hook or liable for those crimes. We've talked about this a little bit on the show before. Just because somebody drives a Ford truck drunk and gets into an accident doesn't mean that Ford should be on the hook for it. And that's all that the Protection of Lawful Commerce and Arms Act does. Is it says just because somebody uses your product to commit a crime doesn't make you liable. You can't be on the hook for somebody's unlawful use of your product.
Yeah, absolutely. And to be honest, and Cam Edwards wrote the story I'm reading from, and I agree with Cam's analysis on that one. If Mexico has a problem with their guns in their country, they need to look at their military, who's apparently missing 30% of the guns we sold them for the military. Yeah,
I think that's a good point. The other point I would make, and this is maybe more controversial, but this is my opinion. I think that the war on drugs contributes to violence, cartel violence, gang violence to a large degree. When products are outlawed, the market for those goes underground, and those underground markets, those black markets, are violent. And you saw that with prohibition of alcohol. What happened to the gangs that peddled alcohol during prohibition?
Oh, yeah.
After prohibition was ended, they fell apart. They had no market. So I think the same sort of thing is going on with the war on drugs. So I think that's where a lot of the violence stems from. I think that's where the large source of the problem comes from. But again, that's just my opinion.
I don't see a whole lot of Anheuser-Busch employees going around and muscling, on the street corners to protect their territory, or the same with Seagram's and Company. That just doesn't happen since it became legal.
Right.
So, yeah, you're right, and there's so many. If just because you make something illegal, if there's a market for it, the market's going to stay there. It's not going to go away. Mm-hmm. And I wish I could say, I don't have the statistics in front of me, and this is a gun rights show. This is not a drug rights show. I don't follow this so much, but I would love to see statistics from places like Colorado, places where the recreational use of marijuana has that affected crime in those states. I would imagine that it has shifted it, if nothing else.
Yeah.
But
and one thing I'll say too, this isn't a drug show, but it's a show about individual rights.
Yes.
And about personal responsibility. And what people consume, how they choose to protect themselves, those are individual decisions. Those are personal responsibilities. And it all stems from our concept of self-ownership, that we can decide how to protect ourselves, how to carry about our day-to-day activities, what we eat, what we consume, etc. So it's a show about individual rights. And to that extent, that those principles carry across many topics.
Yeah, absolutely. Well, we are coming down to the bottom of the hour, Alex, and we're having you back tomorrow for the weekend edition of the Bullet. Anything else you can think of? We got a few minutes left today. Anything else you can think of we should be covering on the legal aspect of the Second Amendment this week?
We're going to see a lot of decisions coming out in the near future, and the fight's not over by any stretch. Just like we talked about with this decision in New York, it's early. It's in the early stages of that case. The judge issued a temporary restraining order, but there's a lot of litigation left to do there, and in many other cases. So make sure you stay involved, stay engaged. That case, Gun Owners of America was involved, but Second Amendment Foundation is continuing to be involved in the courts nationwide. So stay engaged with those organizations. Stay educated, contribute if you can, and keep up the fight.
One last question. I'm kind of dropping the bomb on you this one. This just came into my head. My first bullet back after my trip to Dallas, we had Amanda Sufcool on, and one of the stories was that the Supreme Court declined to accept the bump stock ban case this go around. I don't keep up on the Supreme Court as much as I should. Does that mean that case is done? Period. Done for this year? What?
There are multiple bump stock challenges going on, and there are several still pending in courts of appeals. I can't remember off the top of my head, but there's one that's pending that should have a decision within the next few months, probably by the end of the year, certainly by early 2023. So it's possible that a case like that could come before the Supreme Court this term, or at least in the spring. And what I hope, and this is somewhat wishful thinking, I think it's a real possibility, but at this point it's wishful thinking, is that the court is sort of kicking the can down the road on that issue. And one reason that could be is because last term there was this decision out of West Virginia about administrative authority and Chevron deference. And what sort of
the APA decision, yeah.
Exactly. And what sort of authority administrative agencies should have to interpret the law and make law in lots of circumstances. So what I'm hoping is that the court takes up a case that sort of develops or maybe even overturns Chevron deference, which is deference to these administrative authorities. And that would set up the Supreme Court to accept a case about bump stocks or some other case where the ATF has basically taken on lawmaking authority. They're not just interpreting the law; they're making new law when they do these sorts of things. So that's what I'm hoping, is that the Supreme Court is sort of kicking the can down the road on that one, so that they can more fully develop this administrative law doctrine before they overturn something like the bump stock ban.
Yeah. All right. Well, that is going to do it for us today. Anything you want to plug on your way out the door, man?
Obviously, my father and I have a firm here in Southern Indiana. If you are in need of something related to firearms law, don't hesitate to give us a shout. We handle licensing appeals, expungements, all sorts of things. So don't hesitate to reach out. We also have a firearms training business, and we teach a 5-hour legal class about the lawful use of force and self-defense. So if that's something of interest to you, our website is o2gungroup.com in that regard. So we're certainly advocates of individual rights and the Second Amendment, but we're also firearms instructors and want to help people exercise their rights responsibly.
Very cool. Well, I do encourage everybody, do come join us tomorrow, noon Central Time. Alex will be back. Mike Piwowarski is apparently not flying tomorrow, so chances are good he'll be there. We'll see if we can keep him sober. But come join us tomorrow, noon Central Time, for the Bullet. That's going to do it for us today, folks. Thanks for watching, and we'll see you next time.